I'm Kai Ewing. Here with us today is Donald I. Baker, a partner in the firm of Baker & Miller, and a former Assistant Attorney General in charge of the Antitrust Division. Indeed, Don Baker is the only career Antitrust Division attorney ever to become the Assistant Attorney General in charge of the division. Welcome, Don.
I'm delighted to be here with you, Kai. And I might add that it was really Watergate that made it possible for a career person to become head of the division.
Well, that's at least one good thing that happened after Watergate. Don, I know that you were born in Englewood, New Jersey in 1934, that you attended Princeton University, and then went to Corpus Christi College and Cambridge University in England, and you received your BA in law degree there in 1959. And then, surprisingly, you came back to the States and went to the Harvard Law School and got your Harvard LLB degree in 1961. Tell us how you came to go from Englewood to Princeton to Corpus Christi College to Harvard.
Well, it was sort of a mixture of randomness and opportunism. I wrote my honors thesis at Princeton on question time in the British House of Commons and spent the summer of the Suez War in England. And I said, I somehow have to get back here. And so then I cooked up this deal with Cambridge and Harvard that if I spent 4 years in the two places, I could get 2 degrees and something at the end that worked.
Oh, that's marvelous. Wish I'd thought of it. Anyway, I'm glad you did. What did you do immediately after Harvard Law?
Part of this sort of metronome business, I went back to England as what the English call an articled clerk at one of the premier London solicitors firms, Slaughter and May, and I was educated differently from other people, and I worked on all kinds of odd and interesting international projects. And then, in addition, this was the formative period of the common market and the issuance of Regulation 17. And so that kind of stuff used to come over from Brussels on this slimy paper in French. And I was the only one who, in the whole place, who had any particular idea about competition law. So, you know, it was a great experience. It made me think of the line about, in the land of the blind, the one-eyed man is king.
Well, I must say that it was something like 1961. I think I was over at a place called 18 Austin Friars, London, EC2, England, i.e. Slaughter and May's offices. I wish I'd known you back then. It would have been fun. And as to that's
a real rabbit war and part of the city of London. We'll both remember.
Right around the corner from the old lady on Threadneedle Street. You obviously started a wonderful career there at Slaughter and May, and you mentioned the slimy paper. For those who are watching this, it was thermofax paper because xerography hadn't been commercialized at that point, right?
Yes.
We can remember back to those days too. It was a very flimsy paper. After Slaughter and May, what did you do?
I came back to Boston and worked at the firm of Nutter, McLennan and Fish, and like almost every other young antitrust lawyer of the era, I worked on the electrical equipment cases and traveled all over the country doing depositions in the National Discovery Program, which was a wonderful treat because they had decided that the judges had to preside over these things, and the judges were bored by it. But and so I was in courthouses from San Francisco to Springfield, Illinois, to Kansas City, to wherever. It was a wonderful, interesting experience.
Well, I'm sure it was. I mean, first you go to England and have all these experiences, and then you come and see this country. No wonder you became an antitrust lawyer. I take it you decided you would continue your career in antitrust when you were at that law firm, but then you switched jobs. How did that come about?
Well, first of all, the way I became really interested in antitrust was I took Don Turner's course at Harvard, which was fabulous. And then I went to England and really was, for the first time, was a consumer in a much less competitive society. And I went from thinking that antitrust was a sort of interesting law school course to thinking that there was a really good public policy. And that then led me back to the Antitrust Division after Don Turner had become AAG, and he'd set up this policy planning thing, the evaluation section, which sounded like a great deal of fun. So 6 months into his term, I wrote him a letter and never heard anything. So about 3 months later, I wrote another letter, and almost immediately got a call from Ed Zimmerman, the first assistant, who had lost or had buried my first letter on his desk. And that was prophetic, I think, but that's beside the point. And so anyway, then I came down and interviewed with, and then worked with, Zimmerman and Bob Hammond, and Lionel Kestenbaum was the section chief, and so forth. And it was just marvelous. And I can remember writing to one of my friends back at the firm in Boston and saying, the job here is absolutely fascinating, but you do spend time scrounging for paper clips and secretarial help.
You hadn't had to do that back at the firm in Boston, but I think in Boston you also wrote some briefs in the banking area. Tell us about that. Well,
what happened? That was sort of interesting. The way one's career is just something of chance. I arrived back in Nutter McLennan in February of 1963, when the Philadelphia National Bank case was pending before the Supreme Court. And then one of the first jobs was to write a memo for the General Counsel who was asking whether the antitrust laws really applied to banks. And I said yes, they did, citing Southeastern underwriters and so forth. And 3 months later, the Supreme Court, in a footnote, dealt with the point in my memo. And the point says the defendants haven't argued. And anyway, it doesn't have any merit that the antitrust laws don't apply to banking. So then I was turned loose on every aspect of the Shawmut Bank's operations, and including some clearinghouse activities that were probably not altogether kosher, and a lot of joint lending activities and so forth. So at the end of it, I had a pretty good idea what the inside of a bank looked like, and from an operational standpoint.
Well, I know you've in recent years written on electronic funds transfers and so forth, so you obviously kept that interest for a whole career's lifetime, actually. Right. That's wonderful. Well, what was the prevailing mood in the division when you got there? I mean, you had Don Turner at Harvard. I know when I had him a couple of years before you did, he was concerned about concentration and the merger wave and so forth. Were these issues that confronted you at the division?
Oh, my recollection was that what we were most concerned was just what I'll call disorganized populism and randomness in making recommendations and bringing cases, so that you got quite different results from different sections and field offices and so forth. And I remember from time to time one would have a chat over something like concentration. But I don't, my recollection, which of course we're now 40 years later, and some people, including my wife, would say it wasn't very good 48 hours later, was that we were more interested than they are today in Section 2 monopolization cases. And we were interested in cases for which you could then go to structural relief under Section 2. The government won Grinnell, I guess, just before I got there, or just when I got there, and they just won the second round of United Shoe Machinery, where the court, and the second time around, says, yeah, you've got to break the company up and so forth. And so it was that aspect of structural things. But the other thing that was clearly reflected in the the 1968 merger guidelines was very hard to tell exactly what the government was interested in, and so forth. And I came to this with a lot of enthusiasm because I'd been out in the private sector also trying to advise people on things, and I thought the government being a little clearer and so forth was a good idea. Now the other side of that, whichever it was true every time the government thought about guidelines, was a lot of the career trial people didn't want anything written on paper that could then be thrown back at them in a brief in a courthouse.
But nevertheless, I think you did have a part in drafting Don Turner's 1968 guidelines.
You know,
right?
that was a community project with a lot of talent. I mean, I remember well sitting down like this with Steve Breyer and going back and forth on things, but Turner himself, Heather Hammond, Kastenbaum, Zimmerman, they were all. I mean, everyone was involved. It was definitely a community project, and some of the numbers. I mean, some of the discussion over the numbers was really interesting. Well, why do you pick 5 versus 4? Is it because you got 5 fingers, or you know?
What was the answer?
I'm not sure. Don made the decision, and that's where we went.
I once asked Phil Orita about the 1982 guidelines and the SNP test, if he thought there was any rationality to the 5% price increase, and he says it's as good a number as any. Well, I noted that in 1968, Phil Neal had come out with a report suggesting that there be deconcentration of industry, and Turner didn't go along with that. And at the same time, George Stigler came out and said he didn't agree with Phil Neal's previous recommendation, and he didn't see any particular. He thought that the evidence for correlation between concentration and profitability was weak, is the way he phrased it. Do you recall any discussions about the Neal and the Stigler reports in the division?
Yeah, I recalled some discussions, but really much more just that. I mean, it's sort of interesting stuff. It's interesting to compare. It's interesting to look at the composition of the groups. It seemed to me that you really had almost a 2-track world, and you had the world in which things like that were coming out. The other thing which we were doing, which we thought was really important but didn't seem to be part of these task forces, was all this effort in regulated industries. And I was busily filing interventions at the SEC, at the FCC, sometimes at the Federal Reserve, and so forth. And Turner and company believed that this was something that was seriously important and really backed us.
Well, what about some of the cases at that point? Carter Phone and Utah Pine, a whole bunch of others. Tell us about those.
Well, it's wonderful. It's a wonderful line of disorientation. This is in the late latter part of the Turner period. Carter Phone was the first thing I worked at when I was at the Justice Department. And Carter Phone was a private case that started in Texas and got referred to the Federal Communications Commission by the Fifth Circuit. And what it was about was the telephone company rule that said you can only use our equipment on the end of the telephone line. And so I sat down and wrote a brief and fired it in to the commission, ended up doing the oral argument, having borrowed transcripts and things of lower hearings from other people because we didn't have anything, and we won that in the sense we won the principle of the thing. But then what happened was, is the devil is in the details. And we then fought for 4 years over what the relief actually was going to be. And there was this one great scene which I can't resist passing on to you. AT&T sent in this very articulate engineer to explain to me how risky the whole idea that I was pursuing was. And he wanted to make sure there was going to be a blackboard in my office. And, there'll be a blackboard. So he comes in, draws this elaborate diagram of the network and with all these things that could go wrong, and leaves. And the next day was a Saturday, and my 3-year-old daughter came in. We took the blackboard. It's one of those ones that turns over. And she drew this gigantic pink pig on the back. So then I rolled the blackboard back in my office, and I would periodically entertain people with AT&T's view of the world and my daughter's view of the world, which was surprisingly similar. The final footnote on that is 10 years later, when the basically open access rules that I had been advocating were in place, and I ran into the same engineer on a plane. And I said to him, you're the person I've wanted to see. How's it worked out? Has it been as bad as you said or as good as I said? And he said, well, the technical things are never unambiguous, but a lot closer to what you were arguing for than what I was arguing for.
I think that's a good admission. That's a good admission. What are some other cases that you enjoyed?
Utah Pie was a classic example of the Antitrust Division not getting its act together, because here was a case that there should have been an amicus brief, and there wasn't. And I've heard rumors of whose desk it was lost. The proposal was lost, but I won't disclose it.
I guess that still happens.
It still happens. But on the other hand. One of the things that you haven't mentioned, and was a big regulatory proceeding, was the ABC ITT case, which was a large regulatory proceeding reviewing that merger, and we threw lots of resources into it and blocked it.
So you were very active in this whole regulatory area, trying to intervene on behalf of competition. You also, didn't you get an amendment to the electrical contractors, electrical equipment cases?
That was years later. That was when I was head of the Antitrust Division. And the story there, which is also interesting, is that this involved turbine generators. So it took me back to the same industry I'd been involved in as a young lawyer, and I went to the defendants and said, I worked on the prior cases, and maybe you want me to recuse myself. And they looked at my newly selected chief deputy, Hugh Morrison, who had been the section chief who had recommended the case, and concluded that they'd rather have me. Anyway, it was in the middle, and it was in the middle. They had not price fixed in any conventional way. Westinghouse had simply copied GE's book. And so when the case arrived on my desk, we were having this big meeting on this civil case, I'm saying, what's the relief? It just says don't do it anymore. And then I had this great exchange with George Hay, who was a great champion of the case. I said, George, what do you really want? He said, well, I want a decree that says they'll obey the spirit of the Sherman Act. And I said, that won't do. So we ended up with a long-form decree to go on this complaint. Then the defendants came in and said, Westinghouse is in great trouble because they've sold all this uranium that they don't have, and they might go bankrupt. And this case could just throw them over the side, because the newspapers are just going to say Westinghouse and General Electric caught price fixing again. And so I pulled out the prayer on on our complaint and said to them, look, if you guys will take this as an amendment to the 1961 decree and agree that it's going to be reviewed under the Tenney Act, that's what we'll do. And that's what we did do. And the result was a very important, quite sophisticated piece of antitrust relief appeared at page 31 of the New York Times on a Saturday. And Westinghouse, needless to say, didn't go under.
Well, I understand that at one point a certain attorney general said, what do the riverboat gamblers want now, or something like that. Tell us about that.
He was an attorney general from Texas.
Ah, yes. Well, he would know about that.
Yeah, and the scene was the McDonnell Douglas merger, which involved a merger between Douglas, who was the alternative to Boeing in commercial aircraft, and McDonnell, which was a big fighter and military aircraft competitor, and Douglas was a big military aircraft competitor. So the effects were very bad in a lot of the military procurement markets. And but Douglas had developed the DC-9, which was a great plane, but they didn't learn how to control their costs, and they were going south. And everybody was afraid that if we challenged it, Douglas might just go under. But I spent a lot of time on Wall Street with a lot of financiers and high rollers. That's how I got into the case. And we eventually persuaded Turner and Zimmerman that this was a good case. And so then they took it up to Ramsey Clark, who they talked about it. And then and he said, go back and think about this, that, and the other thing. They went back and thought about this, that, and the other thing, and then came back and were greeted on the last day with, well, how are the last of the old riverboat gamblers? And that was all right. I mean, it was a judgment call. Ramsey Clark really annoyed me 10 years later when he was talking to some, trial lawyers association and said he would have brought the case if the staff work had been better. And since I was the staff work with Alan McAllister, I took personal offense at that.
One could understand that. Well, look, were you involved in the IBM case?
No, not really.
What about the AT&T case?
All over the AT&T case.
All over the AT&T
case.
Tell us a little about that AT&T case.
Well, I mean, this is Tom Kuiper and a talented team, but Tom Kuiper at his absolute best. Thoughtful, analytical. What we were proposing to do, nobody had done in the world, of breaking up communications company between long distance and local, breaking it up between the supplier of equipment and the regulated utilities. That was a little easier to deal with. But breaking up the long distance local was really, a very interesting, exciting exercise. And we'd have a meeting for an hour or so. Then we'd go back and do more homework. Then we come back and we kept on doing like this. It went back and forth. No, it's one of the great things that I ever worked on. But the funny story on this case, which maybe someone else has told you or Tom's told you, we finally decided to recommend and tell AT&T. So AT&T then says they want an meeting with the Attorney General, who's Saxby, a man with not an excessive attention span, so I'm supposed to go to, I'm in the middle of this case, but I'm supposed to go to Los Angeles this day to give a speech. And I say to Tom, should I cancel in order to be there for the meeting with the Attorney General? He says, oh, no. He says, this is just the first one of a whole bunch of meetings. You'll have plenty of time to catch up. So I get on the plane to Los Angeles, and I get off the plane, walk into the field office, and I can still see the telephone slip. It says, Mr. Kuiper, please call. AT&T case filed at 4:05 today. And apparently what had happened is that Saxby opened the meeting saying, I've read the papers and I've decided to bring the case.
Well, that's what he told AT&T as they walked in?
Yeah.
That's fantastic.
And so Kuiper had people running out to tell the SEC to stop trading in the securities, other people to get the signature blocks on the complaint organized, and so forth. It was an amazing. And what else I heard? This is secondhand, but I think I heard it from Phil Arita, who was the president's assistant counsel. Saxby didn't call him up and said, what do you think of my bringing the AT&T case? He said, Phil, I'm going to file this case this afternoon, and the president was on a plane to Japan.
I never knew that Phil was still at the White House then.
Yeah.
He hadn't gone to Harvard to teach.
Oh, no, this was late. This was late, Phil. Phil came back.
Oh, okay,
as Jerry
sorry.
Ford's assistant counsel.
All right.
Remember,
I've got my timetable.
We're in the autumn of '74.
Right.
3 months into Jerry Ford's presidency. But you might think the president doesn't want to get involved in, whether to indict these travel agents or these companies. He might want to know about the AT&T case before it was filed.
I should think so. Well, in your time at the division, I think we went from a system in which the division couldn't bring cases without getting the Attorney General's approval to, at the end of your time as Assistant Attorney General, you could bring them on your own, right?
Right.
How did that come about?
It isn't quite. It isn't quite as simple as that. What we went from I think Saxby was the one that changed it after Watergate. We went from a system in which we used to send up, a half decent sized memo of 3 or 4 pages, and the complaint for the Attorney General's signature, and the Attorney General would send it back or summon you or do any of the kinds of things attorneys general could do. Then we went to a system where you just sent a short memo up and said, I'm planning to file the XYZ complaint and so forth. But the Attorney General always had notice. And certainly when I was AAG, Ed Levy would periodically summon you up to explain the theory of why you wanted to bring this case, and so forth. But I thought at the time, and I think today, you change the dynamics when the Attorney General no longer has to put his John Henry on the document. A quick review of a memo is different from, well, I'm gonna, and so that I think was what was going on.
Well, now, you did a lot of things new as the first career Assistant Attorney General. You've already mentioned appointing Hugh Morrison. I think you also appointed Joe Sims, didn't you?
Yes.
Those were 2 people that were my fellow deputies when I came in under John Shenefield, and I thoroughly enjoyed working with them. And you talk about George Hay, that was a great experience for me too. But
it was a very collegial. It was a very collegial group, and one of the things that we did, which hadn't been done before, was that if I were in town every morning at 9:15, we'd have a 15-minute meeting in which the deputies and the director and deputy director of operations would be there, and it was just a quick thing of, here's what you got to watch out for today, here's what's coming up the horizon. But it was a very good and frankly, Sims, I think, suggested it, but it was a good management tool because we were always on top of each other.
That continued after you left and throughout my time there too, which I thought was a wonderful thing because everybody had a sense of what the other was going to do that day and what was important and what was about to happen. Well, you also had a big role in HART Scott Rodino. Now that started when Tom Kuiper was still the Assistant Attorney General, and at least from what I hear from Tom, he wasn't too enthusiastic about the HART Scott Rodino Act. Tell us a little about that.
Well, the HART Scott Rodino Act was a funny piece of legislation because we think of it now mostly for Title II, which is the merger control, but Title I was what gave the government the power to take depositions and issue interrogatories and so forth. And the way I approached, and Title III was the parents patria provision for the state attorneys general. And the way I approached the thing, but it was well on the way to birth by the time I had to really seriously be involved in it. I thought Title I was terrific, and it was really useful for the division. I didn't realize how important Title II would be. I thought it wasn't a bad idea, but I didn't realize how important it would be. It really changed the merger system from litigation to administrative system. And I didn't like the parents patria thing. And so what happened to me was on a Friday night when I'm actually in Ithaca, New York, I get a call from the Attorney General, says the President wants to see us tomorrow morning at 11 o'clock.
This is when you're the AAG.
Yeah, I've been the AAG for several weeks. And so I managed to get myself back to Washington, a little short on sleep, but and without a copy of the statute in my presence. And so I'm back there. I remember Sims giving me a briefing on what he thought were the hot issues, and going over to the White House with the AAG, with Ed Levy and Ace Tyler, the deputy, and the usual collection of people. And this was an extraordinary experience. I walk in, President Ford is thoroughly nice. Oh, so glad to have you on the team, Don. And then we start.
This is the Oval Office.
This is the Oval Office. Oh. He had the bust of Harry Truman, and the buck stops here, over on the side, and so forth. And about 3 minutes into the conversation, he turns to me and says, "Don, I really want to know what you think about X." And before I can answer the question, he turns off and looks at Ed Levy and says, "I know what you think about it, Ed." Did I have a clue what Ed Levy thought about that?
You didn't.
Well, it only turned out my answer was 180 degrees off. And what was more important?
Well, wait a minute. 180 degrees different from Ed Levy.
Yeah, right.
Yeah, okay.
The president was fine with it, but Levy was a sort of somewhat elliptical character. And we didn't walk out of the Oval Office and have him say, "Well, you know, when the president asked you about Title I, that was really a different answer than he'd gotten from me. Never heard a word about it." So then what happened is I was sent up by the president and the team to negotiate with Senator Kennedy to see if we could get rid of Title III. Because that was really the purpose of the strategy meeting in the White House. Couldn't get it out. So now we're stuck with a statute that the Antitrust Division really likes the first one, modestly warm to the second, doesn't like the third.
But Ed Levy didn't like the first one.
But it turns out Ed Levy didn't like the first one.
And that was the one that gave powers to the Antitrust Division.
He
was concerned about that.
There was too much power.
Too much power.
Anyway, and so what finally happened was the bill passes. The Justice Department recommendation to the OMB is that the president sign the bill, although reluctantly because of Title III. And that was prepared by us, signed off on by the Attorney General, and sent over by the Assistant Attorney General for legislation. I come back on Monday morning. That was Friday afternoon. Monday morning, the Attorney General's written a private note to the President saying the more he thinks about this bill, the more he thinks the President ought to veto it. And he says, don't tell the Antitrust Division about this. And I said to myself, have no fear. They think you were bloody crazy. And so the President signs the bill. This is just before the election. And a week or so later, I get a call from a Washington Post reporter saying, "What can you tell me about the Attorney General's quiet letter to the President recommending that he veto the Hart-Scott Act?" And I looked at my telephone, I think, and said, "Surely you couldn't expect me to comment on a communication between the Attorney General and the President, even if I knew about it."
Well, that's a remarkable story. Now, was there any concern about the other part of Title III, which was that the Antitrust Division was supposed to give away several $1 million to the states?
I don't remember that. And
you left us to have to deal with that one, Don.
No. You know, as Bismarck said, you have to leave something for your grandchildren to solve. And no, but the other thing that happened was the Illinois brick case was up.
Ah, yes.
And I actually argued it, but we thought that if the court went the way it ended up going in Illinois brick, that would greatly reduce the risks of Title III. Although we were advocating. We were on the plaintiff's side in the Illinois brick, and so forth.
Well, that certainly is that fight's still going on a number of years later here.
Well, admittedly, I argued the case. I thought it was a dumb decision at the time, and it's turned out to be even dumber once they didn't preempt, which they would have no legal basis for doing.
Well, you also did something nobody else had ever done, and that's produce an international antitrust guide. Tell us about that.
That was interesting. What happened there was that there was a group called the President's Export Council or something. And remember, in the 70s, everyone was concerned about the antitrust laws were doing in exports and so forth. And so I dealt with them in my capacity as deputy, and said, I don't see this problem. And if you'll give us some real problems, we'll provide some sort of analysis of them, which I think ought to help the situation. And so then what happened is I left as deputy. I came back 9 months later or whatever as assistant attorney general, and my successor as deputy, John Rose, appointed me to be the reporter of the working group to produce these guidelines. And the working group was me, Doug Rosenthal from the division, and 3 lawyers from General Electric, Carbide, and Eaton. And it was always going to be the government's guide, so they weren't, but their job was to, make sure we dealt with the real issues, and so it was a wonderful experience. And so we would, we'd have a meeting on, in which we reviewed, examples A, B, and C from the last meeting. Everyone had the text, and then we discussed D, E, and F, and then as rapporteur, I would write up what I thought the division wanted to say. So it was something that I had very much first-hand experience and created. So we got done that, and I remember sending it off on Cornell letterhead, big thick thing with the draft guide. And when not knowing, of course, that I was going to end up at the desk it was sitting on 3 months later. And sure enough, there it was. Tom Kuiper had saved it for me. Tom wasn't very keen on the idea. He was too worried that it was going to, it would cause too much trouble in case litigation. And it was, as you recall, Kai, the first, what I'll call literary guide. The 1968 merger guidelines were just numbers with very short paragraphs. This was a prose piece. And so what I did, I was keen on the idea, so I then hired Kuiper as my consultant to critique the work that we'd done. And we worked all through the fall, and then the Carter people had asked me to stay over, and I saw no sense in issuing the guide at the end of the Ford administration, so I talked to Carter's advisors and issued it early in the new administration.
Meanwhile, you mentioned Cornell, because when you left as deputy, you went back to become a teacher at Cornell University.
Right, and then came back as head, and then I went back to Cornell again.
Right. In fact, George Hay, in one of these interviews, just said it was your example that allowed him to think he could go back from the division and teach happily.
Yes.
Which I thought was a nice thing.
Well, I must say, speaking of teaching happily, one of the most fun things that I've ever done is jointly teaching with George.
He's a wonderful guy.
And not to mention a first-rate economist.
Absolutely a world-class economist. And he created a whole office of world-class economists, which I think is a remarkable bureaucratic feat as well, I know with your help and the help of others. You also had a lot to do, I think, with the OECD and the UN and those efforts, too, at least in overseeing them, didn't you?
Yeah, but actually the way it worked back in those days was that Tom Kuiper as the AAG and Joel Davidow as the head of the Foreign Commerce section would go off to all these things, and I would supervise the papers that were sent in and so forth. So I think I only went once to OECD when I was Assistant Attorney General, and I was interested in the stuff, but I didn't have the kind of firsthand involvement that I've now had in later years in the ICN and things like that.
Well, you've written a lot about electronic funds transfer, and I know you have a wonderful story as to why you think you got it right early on.
Well, the story is, I went out to give a speech at the Fall Joint Computer Conference in Anaheim and Disneyland and so forth, and and all I was saying is the Antitrust Division knows that the world is going communications and but the next speaker was John Reed, who was the executive vice president of Citibank and head of the back office and one of the great visionaries of the banking field, and of course subsequently chief executive of Citicorp. And he and I talked over lunch. I said, this is just absolutely fascinating. So he said, well, come see me in New York. So I went and saw him in New York. We had a date for lunch, and we sat down at 12:15 and got up at 5:30 in a room with nothing to drink but iced tea, and a room that had a big blackboard. And so he got me so interested in this stuff, which was of great interest to banking. So I was giving speeches and writing articles and doing things. So I got the Antitrust Division out ahead of the banking industry, and I suspect, maybe you were advising banks at the time, that people were all concerned about this thing, and so it wasn't until I left the division that the electronic banking networks really took off. Bill Baxter was also equally interested in this stuff, and he and two other Stanford professors wrote a book which I commented on and so forth and so on.
Well, I still remember meeting both you and Bill Baxter on two different occasions and being so impressed with both of you that I figured I'd never be able to compete in this industry. So it was you all have had both of you, wonderful careers. Looking back, what's the most important antitrust decision of the last 50 years, or maybe two or three of them?
I think clearly GTE Sylvania that brought the whole new way of looking at vertical restraints is probably a pretty good example. And I would note that I was Assistant Attorney General, and we didn't file an amicus brief because we couldn't, in the time period, agree internally what the rule was. I am one who thinks that Philadelphia National Bank was important because it brought order out of chaos, and I'm a great disciple of Derek Bach's famous article, which said you got to have some principles and rules. So that I would put those two on the table. The third one, which I absolutely think is awful, is Southern Motor Carriers. I think that the way the court went in deferring to the states on all kinds of thinly veneered and poorly supervised cartels was a flaming damn disaster, and is one of the things that most differentiates our jurisprudence with most of the rest of the world.
What about General Dynamics?
I remember that was a very important decision. We're talking about the merger case where Potter Stewart turned the tables on that looked like would-be majority. I remember I was teaching as a visitor on the day after that came down at Cornell, and I walked into this class in which there were 60 Cheshire cats grinning from ear to ear. No, it was an important decision because it brought realism into the process and got us away from purely mechanical market shares. In other words, I thought Philadelphia made considerable sense. I thought the analysis of the industry, because I knew something about it, was reasonably good in terms of barriers to entry and things like that. But we went from there to all that. All you have to do is figure out some numbers on the back of something or other, and that was good enough. And that was clearly not the way to go.
Well, that's something I've criticized about Philadelphia National Bank, that we still rely on it, and you're right that it did bring some order out of chaos, but I wonder if it got too much order into it. I don't know. On a personal level, just thinking about personal cases, what was the most interesting personal case you ever did?
Well, the one that probably thrills me the most was bringing a case on behalf of a bunch of citizens in Hawaii to block Gannett's attempt to buy up and shut down the evening newspaper in Honolulu. And that was 9 years ago, and there's still 2 newspapers in Honolulu. The Antitrust Division has always been sort of uneasy in the newspaper area for obvious reasons, and this was in '98 or something like this, and confused by the Newspaper Preservation Act. And the Gannett's felt that this was a license to do whatever they wanted, and we said, no, the Newspaper Preservation Act is about competing voices. We got a preliminary injunction out of a district judge. The Ninth Circuit affirmed it, and it was all a shoestring operation for the citizens group. So that was truly thrilling. Working with Tom Kuiper on putting together the AT&T case was thrilling too.
I was about to ask you, was that what was your reaction when Baxter settled the AT&T case?
My reaction.
Did you like the settlement?
My reaction was if AT&T had offered me a settlement like that when I was AAG, I would have taken it in a heartbeat. and if I could have thrown out the IBM case at the same time, I would have liked that too. So it was
a brilliant political move too, as well as good.
Oh no, that was. I finally had to face up to the IBM case when I was AAG, and I wasn't very thrilled by it, and I frankly couldn't. It was so much like the war on the Western Front. I ended up not being sure whether I disliked IBM's lawyers more than I disliked our own staff. It was a bitter battle.
Well, when shortly after you left and John Shinnefield came in, he sent me up to the IBM staff, and I'll never forget the reaction I got, which was they were horrified that a deputy had come even to look at anything they were doing up there. Well, look, in the merger area, let's talk about that just a little bit. We've got Hart-Scott. We've got expansion of filings to a huge number, 5,000 to 10,000 a year. We get 6 to 10 cases. Have we? Is that really an efficient system that we've got now? Or should we be tinkering, and by tinkering I mean doing some substantial pruning of what we have to do in filings?
I think we should try to rationally cut back on the numbers that get filed. But I am one who isn't just totally turned on by turnover tests, and I was one who pioneered taking the Phillipsburg bank merger case to the Supreme Court because I thought small town banking was a less competitive part of the country, and so I wanted a case that we could shove down the throats of people in small town horizontal mergers. So I'm not quite sure how I would tinker with the thing, but I would. And the other thing is, I frankly would bring more cases than the current crowd have been bringing. Or I would have, insisted on more relief at least. And I would have insisted on disposition of some brands in Whirlpool. I'm not sure what I would have done on XM Sirius. Because I think those two really compete for not only consumers but for networks like and so forth. And so I am the fact we only have 6 or 10 cases a year out of this huge pile is partly I don't think we have enough cases out of the huge pile, but the pile is too huge.
Right. Well, it scares me sometimes when I look at the proliferation of merger regimes around the world, and you have had lots of experience there, Don. In fact, I should recount some of it here. You've been an advisor to the Ukraine and Mongolia on how they set up their regimes. You've represented the governments of Australia, Switzerland, the United Kingdom. You and Bill Rowley have produced a huge treatise on the subject of international antitrust. Give us some of your views about what the rest of the world is doing, and are they doing it the right way, or are we helping them, or are we pushing them the wrong way?
Well, we've made antitrust into such a global religion, and I think that there's a real problem when you have a merger of two enterprises that are leading players in a lot of local markets. And I'm not prepared to say to some small country where the two merging parties are, have 75% or whatever of the market for this stuff, maybe based on intellectual property and so forth and so on, that you can't deal with it on a local basis, which would mean you say, I'm sorry, but you're going to have to spin off something to an independent competitor to provide this service in Timbuktu or something. I don't know. It's a very difficult question. I am less concerned than my friend Bill Rowley on the cost side. I mean, it is complying with all these antitrust things is costly. But it's a pretty small cost in the grand scheme of investment bankers and other things that go into merger costs. But I think that it would be terrific if we could get some treaties or working executive agreements where countries deferred to each other on so forth, and where they particularly deferred to each other on product market definition. So we're all using the same product market, and then then the question is, is this particular country, for some reason or other, a real geographic market as opposed to being just part of a global market?
Well, Bill Rowley was the big chairman. I was a co-chairman of the Ditchley Conference that helped plan the ICN. What do you think of the ICN? Is it doing some good?
Oh yeah, I think it's really a first-rate exercise. I'm working on on some of the working groups, and what we've got, fortunately, in the world is a lot of goodwill and cooperation among the antitrust authorities, and they and you see this in the ICN kind of thing, even where they disagree with each other on something.
One other area before we have to wrap it up, and I've been given the signal to wrap it up. You've also been an arbitrator on antitrust matters. Do you see a real role for arbitration of antitrust disputes? Is that going to be growing in the future?
I think it's bound to grow because I think it works really well where the parties are essentially enterprises, particularly in a vertical relationship or a joint venture relationship, and that works well. What doesn't work well in arbitration, but the courts haven't done anything about it, is where you and I have an arbitration clause, and you participate in a cartel with these other people with whom I don't have any arbitration. How do you deal with that? That's not very efficient. Do I sue them in the court on joint and several and leave you, whatever? So it's a new frontier, and we're nowhere near the end of it, and I don't know where it's going.
Well, Don, you've had a great career up to now, and you're still going 100% strong, and I'm sure you'll take us to the next frontier. Don, thank you.
Great. It's
Real
really
pleasure.
fun. No, it's huge fun to be with you.